Okay, so what we're going to talk about today is new breach regime. I want to run through it at a practical level instead of the esoteric or theoretical level. Right? I want to talk about when the rubber hits the road, how is it going to work, and why we in this position, and why did we get here? How did we get to this point at all? So, what I want to talk about here is we're going to start with a presumption about why we're in this situation in the first place. So, we had the Hayne Royal Commission, Hayne Royal Commission that led to the Hayne Royal Commission response bill. And in that, in the explanatory memorandum to that work, what he talked about there was the central importance of effective breach reporting and how it fits together and what it all means and how those things fit together. And so what's happened now is that certainly in relation to historic failures and legacy issues, and also like complaints from the industry about how some of these obligations were confusing or difficult to understand, we've now got a series of regulatory reforms, of which breach reporting is one, which is really shifting the burden. It's giving more detail, but it's also overtly changing the obligations. Now, those of us who watch the Royal Commission know that although a lack of clarity or confusion was suggested as some of the reasons why some of the licensees were not complying with their legal obligations, a lot of it seemed to be that the people who were making decisions either didn't understand what their obligations were or were, deliberately ignorant of what those obligations were. So again, we're dealing with that legacy. And so now we're dealing with a higher level of prescription and a higher level of expectation that's flowed directly from those legacy issues. Now, I'm sure what we all appreciate as responsible licensees and participants in the industry that there is an obligation to make sure that these things work effectively. Like breach reporting, it's a cornerstone of our regulatory regime. If it's done well, then ASIC can intervene quickly and effectively to minimize problems and identify trends and fix trends before they become problems that impact us and our businesses. So that's what they're looking for. That is the theory that sits behind it, and we'll talk about how all that fits in practice as we go through. I've said this before. We're going to take a practical approach. So we're going to talk about what we see and how we think it's going to work across the businesses that we support as well. And we'll give you some insight as to how some of our clients will approach it and what is done there. You would have noticed, particularly with breach reporting, there's been a lot of fear mongering about, you're going to be reporting all the time. You're going to need massive teams to do this. And I think at least one of the associations was effectively presenting it as the apocalypse. I don't think it's going to be that bad. There is going to be more breach reporting, but that's not a bad thing given that, people were treating it as a discretionary activity. And again, we saw that through the Royal Commission. So again, these things are not too difficult for us to manage. They shouldn't be a problem for a well-run business, because a well-run business is going to be identifying issues anyway. It's in our interest to identify where things are working and what's not working, and how all those things fit together. So we'll see what happens when the rubber hits the road in October. You would know, and there'd be no surprise for anyone on this call, that one of the big changes over the regulatory environment over the last 10 years, and certainly been more explicit in the last 2 to 3 years, is the fact that regulation is now driven by data. It's about data. It's about how these things fit together. The regulator is looking to get more granular and more effective data from all participants, all of the regulated community. So this is why insurers already have been feeding lapse data to ASIC on a regular basis. What we're moving to now is that they're going to be fed more complaint data, more breach data, more reference checking data, more training data. And a lot of these things that we're talking about have been implemented as reforms, but also created as a license obligation. So nestled under your 912A obligations to make it more effective, and also increase the consequences of getting it wrong or not doing the right thing. So it's a real shift in the way the industry is moving. So in the same way that advice has moved from disclosure to engagement and consent, to the surprise of some advisors, the regulator has moved from being reactive and, I guess, driven by voluntary notifications to being hoping to be proactive and driven by ongoing and mandatory notifications. And that's where we're going. This is the change. Now, it does seem a bit frightening in some respects, particularly for some advisors who are going to have to manage that additional reputation and regulatory risks that they never had to deal with before. But again, in a well-run business, we're doing this stuff anyway. We're already monitoring our business. We're doing this. But this is one of the funny things about all these reforms, is that underpinning it, whether you look at 271 or others, there is an expectation that we've all got systems in place that are going to help us generate and do all these types of things. And that's true for some businesses, but not true for all businesses. And so that's where we'll move ahead to. No surprise, again, everyone here should be aware of all these changes, right? These are the main October. We did an article recently in 3 Hit Tuesday on surviving Red October. And we also did a supplementary article that looked at the insurance, because we always focus on what happens at the for financial advisors and licensees, but there are a whole range of impacts that have really hit the risk guides as well, which often slip through. So there's a significant number of changes that have come in, but at the heart of that is this recognition, is that we've often said that in a financial planning practice, your greatest asset is your client data. It's the most significant business asset that you have. And the regulator's woken up to that, but what they've recognized is not only an asset, it's also your greatest liability, right? We saw through the Retire Invest action is that there is an expectation on competent licensees not only to record and retain this data, but to secure it. And so this is one of the emerging liabilities that compliance people now have to turn their minds towards. We've now got to understand, how data is held, managed, works, secured, where we're sharing it. We've got to have systems in place that we can identify recurring systemic trends. We've got to be able to connect disparate sources of information in a way that makes sense, because that is now the licensee's obligation. And it's clearly established as a licensee's obligation. So it's a bit of a challenge for us as compliance professionals to reinvent ourselves from that perspective. This is the number. This is the big number that I think drove a lot of these reforms. This came from report 594, which was ASIC's review of selected financial services groups compliance with their breach reporting obligations. So traditionally we used to have 10 days to report a breach. As you can see here, MLC went slightly outside that 10-day requirement. And look, it might have been a complex matter. It might have been difficult, but my advice to you is if it takes you more than, 1,000 days, it's probably, the default position should be it's reportable. Realistically, they should have made that decision a lot earlier. And this was one of the reasons, is that, was it complex? Were they hiding behind legal advice? Were they just trying to avoid having to report those things? Look, we don't know. We can speculate and we can leave it as a matter of speculation. But Treasury and the Parliament have decided that, well, they're just going to fix the problem. They're not going to wait for the industry to fix it, so they'll change it. And these are the changes we're going to be talking about today. So the introduction of 2 new significant tests, and I'll talk about those as we go through. The extension and definition of what is a reportable situation, what needs to be reported, what doesn't. that 1849 time frame, completely out of the park. Sure, we don't have to report stuff within 10 days, but again, 30 days. And that 30 days seems quite reasonable. And again, it's a deliberate attempt to try to stop that type of delaying activities that was demonstrated by some of the large licensees. Also, we've got an obligation to report others' breaches, and this is interesting in a number of levels. So we're not only going to monitor our own activity and report contraventions or failures to the regulator where they meet those requirements, but if we see others breaching the law in the same way, we have an obligation as a licensee or an authorised representative to report those breaches as well. And I'll talk about that and how that works. And the last point, and consistent with the complaints data as well, is that ASIC are going to publish data. So they're going to expect regular data from participants about breaches, and they're going to publish that. So again, when you think about that, take that step back and go, as an advisor, as a licensee, we've really got to get on top of this, because this is potentially going to be public data. And do we want to be known as a licensee with 5,000 breaches in relation to this particular issue? So it's a good thing from that perspective. It'll really focus management's attention on the importance of the compliance framework and the resourcing of the compliance function, but it does put a lot of obligation on us as compliance professionals to be able to manage that risk in a way that makes sense. Okay, so let's just go to reportable situations, which is a general, I guess it's one of the key elements of the new regime. It's, what type of matters do we need to report to ASIC? What type of, whether we call them incidents, issues, breaches, whatever else, at what point do we need to let ASIC know? Because in the old days, and I mean now, in the old days, we had a series of steps that we need to consider to decide whether or not it was reportable. But ASIC have taken away that heavy lifting from us. They said, look, it's going to be a lot simpler for you. We're going to tell you what needs to be reported. So if we as a licensee or one of our representatives has breached one of our core obligations, so our core obligations are our 912A and 912B obligations. 912A is your license obligations. We're going to act efficiently, honestly, and fairly. We're going to monitor and supervise our representatives. We're going to make sure they're adequately trained. We're going to do reference checking. We're going to do breach reporting. We're going to have effective IDR. All those things, they're your core obligations, right? So go back to 912A. It outlines what those things are. So if we breach those, or we think we're going to breach that, and the breach is going to be significant, then bang, the default position is it's reportable. It needs to go through to the regulator. No harm, no foul, just straight through. So they've shifted. In the old days, we would have been umming and ahhing about some of these things. No, if it hits this categorization and it's significant, the default position is that it goes. So the presumption has shifted. In the old days, we could do it, and the presumption was it didn't need to be notified. From October, the presumption shifts, and the presumption is that it needs to be notified to ASIC unless you can prove it's not significant. If you think that that you as a licensee or one of your representatives is no longer going to be able to comply with the core obligation, so for example, we've got an obligation under 912A to have adequate financial capital to run our business. If we look at our 166 calculations and go, well, for a particular reason, there's going to be a shortfall in the next 2 months, well, and we can't satisfy that shortfall through a contingency or other arrangement, then that's something we'd probably notify. It's a breach of core obligation that we're anticipating, and we'd let ASIC know, because it is, in that case, a failure to have adequate capital to remain solvent would be a significant issue. If we find a problem, your compliance people are doing their job, they've found an issue, management, as is they want further information before we do anything so dramatic as reporting to ASIC. We want the team to look into this and see what it's like. That's fine. You don't have to report immediately, but if you commence an investigation and it takes longer than 30 days, then again, that's one of those situations should be reportable. And this is designed to make sure that things just don't get swept under the carpet. They don't just go, oh, we've got a team looking at it. No, you've got a team looking at it. Sure, they can look at it. They've got a limited time to reach a point about what needs to be done. And so you can see here, the systems that ASIC are actually suggesting you're actually going to need. We're going to need to be able to identify these issues. We're going to need to be able to record them and put them together somehow, because we've got to decide whether they're significant. If we do an investigation, we've got to identify when it came in, when we started the investigation, and when it needs to be notified. And you might practically go, well, once we start an investigation, we'll sit on our systems. Within 28 days, we need to make a decision. So at the 28th day, automatically escalates to the decision maker and say, is yes, no. Because you just don't want to get in a situation where you goes past 30 days and you breach your obligation to report on the basis that you weren't tracking things effectively. So if we think the licensee has engaged in conduct constituting gross negligence, and this is where it starts to get more complicated, because in their attempt to make things easier and more prescriptive and better structured for us, they're actually increasing the obligations on the compliance people or whoever your decision makers are in your business. Because things like gross negligence aren't as simple as you might think to identify, right? So when we're talking about gross negligence, and I'm not suggesting that minor negligence is okay, but when they talk about gross negligence, there's no defined term of what that is, as to, here are the things you should be looking for, or here are the elements that would constitute gross negligence. It's not there. You've got to ascertain it by context, right? You've got to look at it in context, the same way we do when we do an advice assurance review, where we look at the conduct and the outcome in context to try to figure out what's going on. So what they're looking there is to go, you've got to look at a context. Now, the lawyers in the room will go, oh yeah, that comes from the Babcock and Brown global co-investment fund case. Yeah, that's true. It doesn't really help. But what does it really mean when we're talking about gross negligence? Okay, if we think that negligence is just a failure, an act or a omission that is a failure to meet expected standards of our professional service or to satisfy our duty of care, that's negligence, right? A competent professional in this situation would have done that. That's what was expected. I didn't do that, right? That's negligence. Gross negligence has an extra flavor because there's a level of intentionality involved there as well, which is that I knew I should have done that, but I couldn't be bothered. I was reckless, or I didn't know, or I just didn't care, or I didn't want to do it. It's too hard. That's gross negligence. And so the challenge for us as compliance professionals is when we're looking at these things, how do we have, under what circumstances do we have the comfort and the certainty to know that it's gross negligence, or on the other side, that it's not gross negligence? That if we're seeing a pattern of behavior, at what point does it become gross negligence? And this is where you've always got to look at these things in terms of your risk appetite and your consequence management framework to figure out how these things fit in, to see that we're not taking an inconsistent approach, or we're not inadvertently doing the wrong thing. That's a gross negligence piece. The other part, and the last part, is that there's a presumption you're going to report issues where the licensee or representative has committed serious fraud. Now, here's where it gets a bit interesting. So if we look at the Corporations Act itself, that defines serious fraud as an offence involving fraud or dishonesty, being an offence against an Australian law, punishable by imprisonment for, a minimum of 3 months up to life, right? That's serious fraud. The difficulty is that, it puts a big obligation on your compliance people or your auditors to know all the Australian law and the criminal justice framework, to know, okay, well, yeah, that's fraud, but under the New South Wales Act, that's only punishable by 2 months imprisonment. Therefore, it doesn't meet the definition of serious fraud. And so you can see how this is messy and it becomes a bit more complicated, because we don't want to hand over our breach function to lawyers. We'll turn our business into a basket case within a couple of months. We want to be able to control that ourselves, but it means that we've got to figure out practical ways of dealing with this type of thing. And I think practically, most licensees will simply take the position that where they think there is a deliberate attempt to mislead or deceive, fraud, in order to obtain a benefit, or where they think there's an intentional misrepresentation or misadministration or maladministration, where that's clear in context there's dishonesty, where facts are omitted or grossly misrepresented, we might just go, look, that's fraud or dishonesty. We get that the default position where we see that conduct is we're going to report it. But again, this is why your risk appetite for your license and your consequence management are so important, because it's got to be consistent with those approaches, and we've also got to have those tools to be able to make that determination. Same as with gross negligence, right? Because in order to differentiate between negligence and gross negligence, it's a matter of degree, right? It's the same type of nature, but it's a matter of degree. It's the same with fraud or dishonesty and mistake, misrepresentation, innocent misrepresentation. How do we make that determination? This is where your framework needs to give your compliance people enough guidance to be able to deal with that properly. And, in a couple of months, we'll be looking back on the old days and going, oh, awesome. Wasn't it simple? Wasn't it so much better in the old days, and how everything works so much better? Because, now if we get a breach today, what do? We go, okay, do we need to report to ASIC? Well, let's go. Let's look at the number and frequency of similar breaches. Okay, if it's a one-off, I don't need to let ASIC know. If there's a pattern, is there enough to be a pattern to suggest a systemic issue? If not, well, maybe I don't need to report it. We can just handle it in-house. If that breach or that contravention issue or incident sort of impacts on our ability to run our business, well, then sure, that may be something I need to let ASIC know. If suddenly I don't have any money in my business and I'm not solvent, okay, that's a breach I should probably report to ASIC. But anything that, if it doesn't go fundamental to my ability to provide financial services or credit activities, then maybe I don't need to do that. If the failures don't suggest that my compliance arrangements are inadequate, then that's okay. Now, if we take a step back and we go, like, we've had years of remediation, haven't we, through A&P and the other groups, lots of look back, MLC are going through it, BT going through it. That would suggest to me that if we're doing all this remediation, that maybe those licensees' compliance arrangements weren't adequate. But the problem with this type of assessment, the same as we're seeing with the look back, is that the challenge is it's easy to make that determination in retrospect. It's very hard to do it at the time because you don't necessarily see that compliance arrangement is inadequate. The challenge here, and it's always been the case for compliance professionals, is trying to figure out whether or not we have the information to make that assessment, because often information is disparate, it's all over the place, and we don't have access to all the pieces that would enable us to make that determination. Now, sometimes that's deliberate, and sometimes it's just a consequence of the nature of financial services, where you've got disconnected areas and whatever else. The challenge for compliance people going forward is that the regulatory expectation that we have all this information, that we can have access to it and we can get it. The other part is the actual potential loss to clients of the licensee, and we always have to make that assessment. And licensees you might have, in accordance with your risk appetite statement, you might have a figure, 100,000, whatever, 200,000, which is the level on which we go, okay, if it hits that number, we're going to report it. It's a big number, and you might do that in relation to your PI level. any number of ways in which you could do it from that perspective. I talked about the deemed significant ones, and when I talked about that, the shift, the presumption about certain things are going to be deemed significant. Some of these issues are going to be presumed to have to go to the regulator. And we talked about that, in terms of the 912A. But even when you break down the 912A obligations and you go through, and you should be looking at, okay, well, out of those offences or those contraventions, if it's likely to have a custodial sentence of 12 months or more, well, that's something that I should be reporting. Now, again, how are most compliance people going to be able to track that and monitor that as well? What we've done is we've built that into OpenAFSL. So we've tracked the ones that have a custodial sentence of more than 12 months or more, as well as those ones that are civil penalty provisions, so we can track it. But you can see in their desire to make things simpler and more efficient, they're putting an onerous burden on the compliance, risk and governance function to be able to make this determination on an ongoing basis. Really hard. Any contravention of a civil penalty is deemed significant. Now, the problem with this is there are so many of them. So if you go to our website, Short Sport, go to frequently asked questions, we've listed, just in respect to Chapter 7, those areas that have civil penalty provisions attached to it, right? So have a look at that. It's immense. Misleading, deceptive conduct, okay, that's fine. If we see misleading and deceptive conduct, but again, when you're dealing at an advisor level, at what point does simple compliance failure or a mistake or an innocent misrepresentation become misleading or deceptive conduct? And again, this is where we need to take it back to our risk appetite statement and figure out how it's going to fit together and what it means. The last one is probably the most problematic: a contravention that is likely to result in material loss or damage to a retail client. And this is where, I keep bringing up your risk appetite statement, your consequence management framework. This is where you really have to start, is that you need to be clear at a licensee level what material loss or damage is. Now, the reality is when they look at these types of things, they always talk about, well, it depends on the person's circumstances. Okay, that's fine. It's got to be, it's not a one size fits all. It can't be $10,000 because some clients, $10,000 won't matter. You might put it $100,000, but for some clients that's okay. Others, they're never going to have $100,000, so it's not going to work. So the challenge for everyone on this call as compliance experts advising licensees is to try to figure out, what parameters do we put in place to guide that decision making that's not going to cause us grief somewhere down the track? What is a sensible and effective way to manage that piece? Now, how would you do it if you want to avoid the situation where licensees use context to just exclude themselves from having to report anything? So those levels of materiality have to be reasonable, and you might take it back to the materiality thresholds you've done for records of advice, or you might do something else. There's any number of ways in which you can do it. Loss or damage is a lot simpler, it's ordinary meaning. But when you talk about loss or damage, it's important to go, it also encompasses non-financial loss or damage. Okay, so it's not a simple matter of going, they've lost $20,000, it's under that level, because you've also got to look at, well, but what are the material non-financial losses or damage they've suffered? And how does that work? So again, your risk appetite statement has to be a bit more flexible and a bit more nuanced if it's going to be effective to satisfy the obligations under the new breach regime. I talked about the civil penalty provisions. There are lots of them. So you got your general obligations, fine. I've linked them there. Obligation to lodge breach reports. It's a nice circular piece, isn't it? But one of the elements here is, and if you attended the complaints one as well, is that the way in which ASIC bring the regulatory standards, the guides, into licensee obligations, right? So they become licensee obligations, which means they've got more force than if they were just general statements of regulatory expectations. So breaches. you've got an obligation, and it's a license obligation, right? So it's going to have consequences if you're not doing it. So if you're not complying with the obligations to report significant, then it's a breach of your license, which has significant consequences. The disclosure requirements in Chapter 7, and like I said, on our website, we've put, yes, Aaron, the slide deck will be made available afterwards, and all the links are built into the presentation as well. So I'll send that out after the session as well. If you've got any questions as we go, you can use the chat function as well, and we can address those there. So where was I? Oh, Chapter 7, lots of those. They're on our website as well. Even the credit stuff's there as well. So there's a whole range of things that have been built into those civil penalty provisions. So you can see, you know, licensees complain about the cost and complexity of compliance. But one of the things to bear in mind is the increasing expectations of compliance professionals in terms of their education, not just and their practical skills and their ability to interpret this in a consistent and effective manner. You know, traditionally, a lot of compliance has been dominated by, you know, a ticker box approach, minimum standards, all those bits. And what we can see here is that our industry has shifted the same way as the financial advice has shifted. In the same way that financial advice has been focused more on the professionalism and the competence and capability of advisors, compliance is doing the same. You know, you look at all the things we now have to understand that we have to be able to put together, that we have to understand the law, we have to understand the criminal justice framework. We need to have a real understanding and a subtle understanding of the difference between civil penalty provisions, offences, and the restitution powers of ASIC. We need to be able to put all this together. We need to understand, you know, negligence. We need to be able to differentiate between gross negligence. We need to understand fraud. We need to understand technology and how we can do this. We need to understand recurring and systemic issues. Our obligations have increased significantly, right, as professionals. And so it's always important to bear that in mind. As much as licensees are under pressure to adapt and move forward, and advisors are, we're not just sitting there. We're actually being pushed in the same direction, and actually further, because we've got to be ahead of the licensees we advise and ahead of the advisors we support. So we're in a dynamic industry, which is great, but there are a lot of obligations and a lot of pressures on us to keep going. We talked about timing recently. It's just at 30 calendar days. So 30 days is a critical factor. So on your systems, whatever you put in place, make sure that you're tracking these things. You're letting people know within 30 days. You're notifying clients. You're letting ASIC know. These are just basic processes you should be able to put together quite simply. And when I talked about notifying clients, this is where it comes in is, you know, if you identified a reportable situation and it involves clients, right? So you've got to take reasonable steps, which is a general term to notify the affected clients. That's okay. And this becomes even more important if it falls within one of those areas. It's breach of core obligations, gross negligence, serious fraud. So any of those big issues. The obligation is us, if we think people are affected, even if they don't know, to notify them. Right? This is the issue. So if we think, for example, one of our advisors has been stealing client funds, it's not enough to just go through and go, oh, we've found the 4 clients that have had money stolen, because we can see from the portfolio. Our obligation is to notify all the clients that might have been impacted. So all the clients with whom that advisor might have dealt, right? To let them know, we're investigating this, we're doing this, you know, this happened, here's what's going on. Now, there are some qualifications there as well, right? So one of the things about the notification obligation, sure, it's got to happen within 30 days, whatever else, but we've also got to make sure that if we think they've got a legally enforceable right, and this is where I talked about the the increasing skills of compliance professionals, because here we've got to make a legal decision. Does the affected client have a legally enforceable right to recover the loss or damage? Because if they do, we've got obligations to notify them and ASIC. But if we don't think they've got a legally enforceable right, then our obligations to notify them are different. We're not under the same time pressure. And so you can see, again, if you're a compliance professional working with a responsible licensee, your obligation is less about going through the mechanics of this, of the compliance arrangements, and more about providing strategic advice about the outcomes of the compliance framework, which is a good thing. It's moving compliance from being a bureaucratic function to being a strategic discipline, but understand the obligations that come with that transition as well. I talked about informing clients. You've got to inform them within 30 days. If you want to do an investigation, it's fine. Like, let's succeed. You're not sure about the extent of the problem. You've identified an issue. You want to move ahead. Great. What's going to happen? You go ahead and do it, but you've got to notify people. You got to notify the affected customers within 10 days. All right, I've completed the mandatory investigation, and you've got to remediate losses within 30 days. So 30 days is one of those key elements. So again, whatever systems you put in place have to be able to track this so that we can do this properly. This is the scariest part of the changes. And when I was a kid, there was Mad Magazine, and they used to have a cartoon called Spy versus Spy, which, one spy would do something to the other, and it just escalate until it was a ridiculous, mutually assured destruction scenario. This is where I think this might go, because what happens now is that licensees have an obligation to report breaches and do all those bits and pieces, but licensees also, and authorized reps also have an obligation to report the contraventions that they see caused by other licensees or advisors. So it's an obligation to really, we're all responsible for the financial services industry. We've got an obligation. So it's not enough to just, silently judge another licensee who's doing something poorly or in contravention of law. The expectation is that we'll report them, that you'll report them and you'll notify ASIC. And that seems quite reasonable, except you've also got an obligation to notify the other party as well. So this is where I worry about, if I've got to notify ASIC that I think, Bob's doing the wrong thing, it seems counterproductive to tell Bob, I'm telling him that I'm going to report him to ASIC. Seems rife to abuse and unintended consequences, but we'll see what happens from that perspective. If you do need to make that type of declaration notification to ASIC, and you can do that through the ASIC portal, you can do that now, actually, when you go through the breach reporting. It's called a voluntary notification. If you want to do a voluntary notification or notify them about a competitor or peer or something else, one of the things to think about is if that notification is done in good faith, like you're not trying to extort another party, not trying to apply commercial pressure, or there's not another reason for it, then your notification to ASIC attracts qualified privilege, which means it's a defense against defamation and breach of confidence and other actions for doing that. But if it's not done in good faith, then you lose that qualified privilege. So again, as a compliance professional, if you're going to be facilitating the breach notices to ASIC, you need to make sure that before you do that, there is a reasonable basis for those notifications, particularly if you're notifying them about another party. You need to satisfy that there's enough evidence to give you a reasonable basis to do that, because otherwise you could be exposing yourself and your business to actions that you don't necessarily want to deal with. This notification reason is one of the reasons we've been advising our clients that if you want to sell client books, do it now. Do it now and make sure it's done and locked and finished before October. If you want to buy client books, delay until after October, right? Because that's when you'll get the most benefit from the changes in the regime. Because even though when you're looking at prospective purchases, or acquisitions, or disposal of client books, and what there's a deed of confidentiality or some type of other contract to make sure that everything stays between the parties. The changes to the law invalidate that, so you don't have a defence of saying, "Oh, there's a contract in place." So what that means is either you've got to do those transitions before October, or when you look at those going forward, you engage an external party who's not a licensee and who's not an authorised rep to do those inquiries, because otherwise there's an obligation to report and escalate them. Is the notification of other licensees broader than when personal advice has been provided? Yes. The obligation runs, because it's 9128, it doesn't have to be limited to just financial product advice. So, for example, if there's evidence that the other group is not responding to complaints, so your client, who was a former client of licensee X, has lodged a complaint, hasn't been acknowledged, hasn't been responded to, there's been no interaction, then that is an issue you could notify ASIC about you under this obligation. It's appropriate to do so. It's a contravention of their 912A obligation, and it doesn't have to link to the advice. Likewise, if they are authorising advisors who you know are banned or incompetent or whatever else, then that is a notification piece. It does not have to be linked to advice. It's a broader piece. But it's a good point, because it ties into, your FASEA standards as well. So if you look at FASEA standards 10 till 12, they all focus on our obligation to the industry, the obligation to the profession and the community. And this is they sort of complement the licensee's obligation here. But what's more than just making sure the SOA is good, we're trying to make sure that consumers are properly looked after. Hopefully I've covered off a lot of those issues there, and I'll send the slides out to you. If you have questions, need more guidance, reach out to us. Happy to help out from that perspective. So if you're going back to work, what do I think you focus on? Review your framework. In particular, and I said this, your risk appetite, your consequence management framework, don't leave those out. A lot of people focus on the breach policy, but these things are all connected, right? It's all connected, as the X-Files told us. So we just got to make sure that we're looking at all the structural elements for our compliance arrangements and making sure they're working and making sure they're understood, which is why make sure you train your staff, not just the advisors, but the broader operational staff, to be able to recognize these things and move ahead. Sell clients now. If you're going to sell clients, sell them now. Don't wait until after the new regime commences, because then you're more vulnerable from that perspective. And as a general rule, subscribe to 3 Hit Tuesday, because we cover this stuff on a regular fortnightly basis as well. I'll put some links in the further resources about articles that might help you and help you address some of these issues. Consequence management, RegTech, managing an AFS, all those things are useful ways, and that might help you as well. And if you want to talk about systems and how you can manage these types of things, happy to have that conversation with you as well. And I think we're almost at time. So are there any further questions you want to talk about, or anything you'd like to ask?
No questions from our end. Thank you.
No worries at all. Oh, well, if there's no further questions, we might just, close it now. Thank you for your time and your attention, and I'll send the slides out to you shortly, as soon as I can, actually. All right. Have a great day, everybody. See ya.